man?
Good, how are you?
You got the gun for?
Why I got the gun? What you got the gun for?
Because I'm authorized.
Alright, well, I'm authorized to
Get down on the ground.
Get on the ground.
Get down on the ground.
You're going to have to shoot me, man.
Jeffrey, it's all you, brother.
All right, once again, Jeff Weinhaus calls from the friendly confines of the Eastern Reception and Diagnostic Center, otherwise known as the Bon Terrible Prison. I'm in here. I've been convicted of an attempted murder on a policeman by trying to shoot him. And they actually dropped that charge about a month before my big trial, and they amended it to attempted to draw a weapon to shoot at Sergeant Folsom, and of course that is no longer what they call an A felony here in Missouri. That would be misdemeanor neglect, which is like a 3-year sentence. So anyway, and let me pick up for here. This is a supplemental thing I filed with the court while I had no counsel, and we were talking about Sergeant Folsom and how many times he lied throughout this event, and carefully going over the trial transcripts and a few other things. It was concluded that it's 15, 20, 25 lies of what Sergeant Folsom and Corporal Mertens may have lied about under oath in a court of law, and they do not even consider drawing whatever the evidence leads. They do not even consider a perjury charge on their behalf or just misuse of public office. This is just craziness. In supplemental number 17, and that's where we're going to pick up. My God, this man is on Fantasy Island, and I'm talking about Sergeant Folsom. You can't believe anything he says. And I throw in this scripture. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh a lie. He speaketh of his own, for he is a liar and the father of it. Defendant victim, and this is the big thing, acting without competent, effective assistance of counsel, therefore requests that these charges be dismissed based on the facts of this matter and of the law. How can a defendant victim be charged with 2 counts of attempted assault of law enforcement officer, even according to the perjured testimony of those so-called law enforcement officers who did attempt to kill him and cause serious physical injury to me? Defendant victim never even allegedly got his firearm out of the holster, and we all know this by now. Just simply look at the picture of the gun reflecting on the tail light of my car, and that shows the gun on my left front hip, and not the right, as the highway patrolman and the prosecutor maintained throughout the whole trial. Defendant, okay, let's see here. There is no way that the defendant could have attempted to kill or cause serious injury by shooting them. Of course, the ones that maintained the defendant victim were even tried to draw were Folsom and Mertens. Sergeant Folsom and Corporal Mertens' testimony of the event does not even remotely coincide with the audio recording of the event, and that is before. This is all before I had the video of it all. So we did get the video, and that's a miracle in and of itself. A miracle that I was able to sustain 2 to the head, 2 to the chest, and then that I was actually not permanently harmed by not going to therapy in the custody of the sheriff. They took me to their doctor. The doctor pronounced me healthy and whole and all this and that. And here I sit. So they cut my therapy off. Just the craziness. Folsom basically writes a novel as to what happened in less than 12 seconds. He used 529 words to describe what happened in 12 seconds. Folsom claims in the audio interviews of the event conducted by the Missouri Highway Patrol that Folsom stated to the defendant victim, Jeff, I got your computers right here. Yeah, I got the papers right here. And going back, that is not even on the audio nor on the videotape. didn't say anything to me. And when I questioned at trial about it, he said that he was role-playing with his partner, that he didn't actually mean. He actually didn't say that. Or he was far away from me and couldn't hear anything. And this is the most important one. From the Highway Patrol Supplement number 17, and that is the audio recording of Folsom. He also alleges, he said, "Just get your hand off the gun." And that's at 20 minutes and 22 seconds into that recording. Of course, if you listen to it on the audio or on the video, he never told me that. At trial, he further goes on to explain that my lawyer pushed it right to the edge, but never really made a big deal about it. My lawyer said, questioned Folsom, "Why didn't you tell him to take your hand off the gun?" And then at trial, Folsom said, "I didn't have time to." So another blatant lie. Just long enough to say, "What are you doing with that gun?" is what he claimed into his interview too. He said that as well. So there's 4 basic lies this man's contending with him about the gun. Thus, he contradicted in his initial report, and that's the Highway Patrol Supplement. Thus, contradicts his previous statement about the papers and getting hand off the gun. By the way, Folsom, this is his second patrol shooting where he killed someone else in 2001. To the best of the defendant's knowledge, that victim did not survive, and that was before, once again, I got all the discovery. Martin's interview, which is Highway Patrol Supplement number 13, also contends that Folsom stated, got your papers right here. None of these statements are on the audio recording of the events that Valerie Weinhaus obtained. She actually recorded the whole thing while I was on the way down to meet them, covering. And then my Missouri Highway Patrol Supplement number 16. Furthermore, Mertens admits that Weinhaus never even saw me, turned toward me, never looked at me, never said anything to me. Mertens' interview of MHAP Supplement 13 at 14:55 into that tape. So much for the who, what, why, how of the alleged crime of attempted assault, first degree on a law enforcement officer. And in the beautiful United States of America, along with the state of Missouri, we're supposed to have equal protection under the law, according to Article 1, Section 2 of the Missouri Constitution. In the state of Missouri, a Class A felony is assault. Class A felony is a 15-year sentence. They sentenced me to 30 years. So much for equal protection. The police are more equal than others, as we know from all across this country. As you see guys, people shot in the backs, running away throughout this country, and the police are never, ever held accountable. So we're in a whole lot of trouble. And then definitely the police are and certainly more above the law than we the citizens, the ones who pay them. All right? It has been proven throughout the interviews that they are lying. They are lying. In light of these facts, that both FBI Special Agent were on the scene and witnessed the events, have testified to the Highway Patrol investigators, Sergeant Patrick D. Cunningham. When Weinhaus stopped, he was standing, this is what he says, when Weinhaus stopped, he was standing in a bladed position with his right side exposed to me. Agent Cunningham's view. That would be the gun side where the weapon was allegedly holstered. Agent Cunningham saw Weinhaus position his hands to his front waistband, and that would be the get my hands into permission to get the video. And he then observed Sergeant Folsom raise his right hand. He could not hear what Sergeant Folsom was saying. He saw Folsom raise his right hand in the air, drew his handgun with his left hand, and stepped backwards. He then heard several gunshots and witnessed Weinhaus fall to the ground. The important thing in Agent Cunningham's outlook of all this is he did not say he saw a gun nor that he observed me attempting to draw it. Special Agent Mike Marshak said he observed that Weinhaus reached to his front waistband, and at the same time he observed Sergeant Folsom raise his right hand, take a side step. At that point, he observed Weinhaus falling to the ground. 6 other people who were on the scene on September 11th at the gas station will testify to the fact that when the defendant victim fell to the ground after 6 shots were fired at point-blank range, 2 hitting the defendant in the head, 2 hitting the defendant victim in the chest, defendant's hands were empty. How can defendant's victim be charged when everyone else other than the ones who tried to kill him and have been, to say the least, less than truthful, are the ones who alleged Weinhaus attempted to draw? Has brought up in the motion to quash, and it has also been proven to this court that Folsom lied to the grand jury concerning the resisting arrest charge. As to the count of tampering, the only video of the Bulletin Man broadcast entered into evidence by the prosecution of the matter does not even mention Judge Kelly Parker. And that's the guy, the judge, who said I was trying to tamper with him. I didn't have a case before him. I had no monetary gain to gain between all that. What I did put on their videotape is that how Sergeant Kelly Parker, how Judge Parker actually got his job. He was elected as a state representative. Got the governor to put in introduced a bill. Got the governor to put another judgeship in the circuit he came out of, and then Judge Parker was actually appointed to be that judge, raising his salary from $31,000 a year to over $100,000 a year. So there we go, folks. Justice American style. All right. So, hey, how can the defendant victim? Go ahead, Rudy. You got something to say?
No, I'm sorry, Jeffrey. I did have a question about the very first statement you made, but I did not want to interrupt you. So you go ahead and finish.
No, go ahead.
Well, when you very first started off, you mentioned about a law that a charge that was brought against you, and the level of felony or misdemeanor was changed after they charge you. Can you elaborate on that just a bit more?
Yeah, they initially charged me with attempted to murder these guys by shooting him. Okay. And I guess someone got to the prosecuting attorney and said, hey, what you've charged him with is impossible to convict on because he didn't shoot him.
Yeah.
So he came back, and of course my lawyer was down with this too because he failed to raise it, that I was actually convicted, and we can get into all this later on, Rudy, because it's so technical.
Okay.
And so diabolical what they did. But the jury actually signed off on the fact that I shot the guy because Parks changed the charging instrument to attempt to draw a weapon to shoot him, but he never changed the jury instructions. So the jury had the instructions that I shot at the man. The jury sent back a note to the judge. What is the difference of first-degree assault? I mean, what is the difference, the definition of first-degree assault, and what the judge told the jury is refer back to the instructions I gave you.
Wow.
So,
wow.
Yeah, so, I mean, I shot this guy 6 times, or whatever. You know?
Right. Incredible.
Yeah, so I'm just about done here, and I thank everybody for hanging in here. How can the defendant victim be charged when everyone other than the ones who tried to kill him have been, to say the least, less than truthful, are the only ones who allege Weinhaus attempted to draw? As brought up in the motion to quash, it has been proven to this court. Folsom lied to the grand jury. All right, I think I've already went through over all this. I'm sorry, folks. Okay, Article 1, Section 52, the morphine charge is not even on the search warrant and was initiated absent any probable cause. And like I said earlier, I had a script for that. Furthermore, there are 3 more very important elements essential to the crime to have been. Okay, one is actual intent, and that's Latin means re. 2 is actus reus, the actual criminal act. And 3 is corpus delicti, the body of the crime. And aggrieved party, someone who has been actually injured, suffered loss, or was harmed. None of this evidence even remotely constitutes a crime. In this gross miscarriage of justice, defendant victim acting in without competent and effective assistance of counsel has been indeed adversely affected and, to say the least, prejudiced by this prosecutor's unethical and egregious behavior. Justice shall not be for sale, denial, or delay in Missouri, and Article 1, Section 14 of the Missouri Constitution. Therefore, for good cause being shown over and over again, for the lack of an injured party or any element to constitute a commission of a crime by the defendant, the court, now lacking the subject matter jurisdiction, has no choice but to dismiss this most malicious matter. All defendant victim Weinhaus did was quote the Missouri Constitution, which does not constitute a threat. For that, he got his computers and cameras stolen, shot 4 times. The United States Supreme Court, with equal justice for all on the front of it, has ruled that cursing public servants is a right and forms no basis for criminal complaint or any adverse police action. Furthermore, the only businesses protected by the United States Constitution is a free press. Defendant victim Weinhaus is still acting without competent, effective assistance of counsel. It concludes this matter with this thought: I have suffered the loss of my home, marriage, 6 pints of blood, the computers, printing press, which I made a living, 180 days of my life, and after 4 years, man, we're way up past 180 days. And because of a couple lying, attempted murdering cops and a prosecutor who may be experienced but is less than professional, and how I pray for them all and this court as well. Hold on a second, let me turn to the last page. Just about there, folks. One of these days, I'll make it all worthwhile. Everybody contributes to my campaign for freedom will certainly be forever in not only memorialized in my mind, my 6 children's mind, but also the fact that God Almighty will take care of you. So let's see here. I actually turn backwards. Let's see if we can get over to the other side here. All right, I found it. I appreciate you all tuning in. Travesty of justice, T.A. Parks is making a mockery of this court and the entire justice system in Missouri. His actions rise to the level of willful misconduct in public office. Article 1, Section 16, Missouri Constitution. He is a menace to society and should be on the one on trial for allowing these troopers so far to get away with their crime against defendant, victim, and the citizens of the state. It's the aforementioned facts and review of discovery offered in this case can't convince this court that the only conclusion is to dismiss this charge. I don't know what will. Perhaps competent and effective assistance of counsel, which the defendant has been denied, might, though the facts of the case will not change regardless who the counsel is. All right. So there we were. And we just call upon Jesus to in conclusion here, until the time the defendant victim is afforded the opportunity to be set at liberty through the non-excessive bond, Article 1, Section 21 of the Missouri Constitution. Then I will be looking for the rest of this and call upon Jesus, the judge of justice, is soon to come, to be ready. If God its power, perhaps this honorable court will review the Highway Patrol Supplement number 11 for some very graphic photos of the only injured party in this matter, and that would be the defendant victim. I've been kept alive and brought through all this by the power of Jesus' name. So that's that. That's called what I've decided. Now, Prosecutor Parks' response to this was he filed what they call a motion in limine to limit certain testimony from getting into the trial. And his motion for limine was to what I could not call myself a victim. And the judge agreed to it. Parks said it might confuse the jury. So if I were to go trial on myself, I couldn't call myself a victim. Let that sink in for a minute, folks. the only one sitting there. Any pictures? So there you go. That's Justice American style. What I would like this whole little thing to get around to is the Attorney General of the state of Missouri. He's trying to defend.
This call is from a correctional facility and may be monitored and recorded.
Our claim to the what we just for me to get justice. He is no longer worried about being the Attorney General, who the people so gratefully gave him the office of back in November. He has announced, as of this week, that he is seeking the office of the United States Senator, and he hasn't even finished 1/4 of his time as the Attorney General of the state of Missouri. Don't let him get away with this, folks. This is a cry for justice, and we anticipate God will take care of these things. But please pray for a contact, email, just whatever you can to get a hold of the Attorney General of the state. His name is Josh Hawley, and of course we have an email that Josh Hawley sent Rudy back over the summer, promising that he would look into justice. But here I am. It is now fall, and I'm still sitting in prison. Thanks for your time, Rudy.
Hey, thank you, Jeffrey. You mind if I ask you 3 quick questions for my benefit before we hang? Okay, just 3. The name of the Sergeant Henry Folsom, I got that one, and then the Mertens. Do you remember his first name?
Scott.
Scott Mertens, and then what was the name of your prosecutor, brother?
Bob Parks.
Bob Parks. Okay. I just wanted to know who specifically to lift up in my prayers that they would repent and.
I don't know Parks' number. I do know his address because I sent so much to him. But he resides. His office is at 15 South Church Street, and of course I put in there after Church of Satan.
Yes, right.
Church of Satan Street, because that's where this man's coming from.
Yep, I understand.
All right.
Okay, brother. Thank you for sharing the details of your case, and we're going to continue to lift you up in prayer and pray that God intervenes and leads us in what to do. Because
at the end of the day, Hawley has one witness to really call. That's Henry Folsom.
Yeah.
And we just proved, and I can go on all day long, going through the trial transcripts and this and that. That man had told at least 15 lies.
Yeah.
Now, how do you put a 15 liar? I mean, he can't tell the truth. How do you put him on the stand?
Yeah. Yeah, you're sitting in prison. You're sitting in prison because of the testimony of Sergeant Henry Folsom, who has proven over and over again to be no credibility whatsoever. He has proven to be lying multiple times under oath.
Yeah, and the prosecutor and the judge are just as dirty.
Yeah.
They let him get away with it.
Yeah, I understand.
Very good, Rudy.
Okay, God bless you, Jeffrey. Take care. God bless. Bye-bye.
All right, God bless you.
The call